There are moments in life that are so specific in their absurdity that no reasonable person could have anticipated them. Moments where you come home after a long day and find something waiting for you that your brain genuinely refuses to process for several full seconds because the information it is receiving does not fit any category of experience it has previously stored. I have had a few of those moments in my 52 years on this earth. The afternoon I came home and found a full-sized burgundy Cadillac Escalade parked inside my locked garage is the one I will be telling people about for the rest of my life. My name is Owen Garrett. I live in Cedarwood Park, a planned HOA community in the outer suburbs of Hennessy County, Virginia. I have lived there for 6 years. I am a civil engineer by training and profession, which means I spend my working life solving problems that other people create through insufficient planning and excessive confidence, and which also means I have a fairly high tolerance for situations that require methodical documentation before any action is taken. I am not an impulsive man. I am not a man who yells across fences or leaves angry notes in mailboxes. I am a man who reads documents carefully, keeps organized records, and believes, perhaps more than the evidence always supports, that systems can work if people engage with them correctly. Cedarwood Park is a development of about 90 homes, each with an attached 2-car garage, built in the early 2000s on a former agricultural parcel that had good drainage and terrible soil composition, as I discovered when I had the foundation inspected before purchase. The neighborhood was pleasant in the specific way of planned communities: uniform setbacks, consistent landscaping requirements, a shared pool that nobody used past September, and an HOA that ranged from mildly annoying to competently managed, depending on who was currently on the board. Sandra Fitch had been on the board for 4 years when I moved in. She had been the architectural review chair for 3 of those 4 years, and had been, by all accounts, a reasonable and procedurally sound committee chair until her husband's promotion moved them into a larger home on the other side of the development, and she decided, apparently, that the additional square footage entitled her to an additional measure of authority over everyone else's. The first time I had a direct interaction with Sandra Fitch was about 2 years after I moved in, over a matter so minor I am almost embarrassed to describe it. I had installed a basketball hoop in my driveway, the freestanding kind, not a permanent mounted structure, for my nephew who visited on weekends. Sandra knocked on my door that Saturday afternoon and told me, pleasantly but with the particular firmness of someone who has rehearsed their message, that freestanding recreational equipment was permitted in driveways only during active use and had to be stored out of public view when not in use. I said I wasn't aware of that provision. She said it was in the Community Standards Guidelines, Appendix C, Paragraph 7. I said I would look it up. She smiled and left. I looked it up. She was right. I stored the hoop in the garage between sessions. What bothered me was not that she was right. What bothered me was the way she delivered the information, the way she had positioned herself at the exact threshold between neighborly advice and official enforcement, so that refusing to comply would have felt like defying the HOA, but complying felt like answering to Sandra Fitch personally. It was a small thing, and I did not make anything of it at the time, but I noticed it. I filed it in the part of my brain where I keep things I am not ready to think about yet. Over the following 2 years, Sandra Fitch appeared at intervals in my life, the way a persistent mechanical problem appears in an agging vehicle, not always present, not always causing active trouble, but never quite gone either. There was the matter of my side yard gate, which she reported as the wrong color beige when the community standard was sand, a difference visible only to someone with a color reference card and a sustained grievance. There was the matter of my outdoor furniture, which she described in a courtesy note as weathered beyond acceptable standards, when in fact the furniture in question was teak, which is supposed to gray. That is what teak does. It is not deteriorating. It is behaving exactly as the material is designed to behave, and anyone who had spent 30 seconds researching teak furniture would know this. I wrote a polite note to this effect and included a link to a teak furniture care guide from a nationally recognized outdoor furniture retailer. The courtesy note was withdrawn. There was also the matter of the parking. Cedarwood Park had a street parking policy that was, in fairness, clearly spelled out in the covenants. Overnight street parking was not permitted between the hours of midnight and 6 in the morning. Guest parking was available in a designated lot near the community center, about 300 feet from my house. My own driveway and garage were mine to use as I saw fit, within the general provisions about not operating a commercial business from a residential property and not storing inoperable vehicles in visible areas. I had 2 cars, a work truck I used for site visits and a personal sedan, and I kept both of them in the garage or the driveway without issue. What I had not anticipated was that Sandra Fitch would ever need my garage for anything. Which is why, on a Thursday afternoon in October, when I drove home from a 2-day site visit and pulled into my driveway and pressed the button on my garage door opener, and the door went up, and I sat there in my truck, staring at a burgundy Cadillac Escalade that was parked where my sedan was supposed to be. I sat there for what I estimate was a full 30 seconds before my brain finished the sentence it had started. The garage had been locked. I mean that in a specific and important sense. The overhead door had been closed and secured with the automatic lock engaged. My personal code was required to open it from the outside. The interior door from the garage to the house was locked with a deadbolt that required a physical key. I had not given anyone that code or that key. I do not hide a spare key outside my house because I am a civil engineer and I have read the statistics on what happens to spare keys hidden in fake rocks near back doors. I sat in my truck for another moment, and then I got out and walked into the garage and looked at the Escalade. It was Sandra Fitch's car. I knew it was Sandra Fitch's car because it had a Cedarwood Park HOA parking permit hanging from the rearview mirror and a Realtor of the Year bumper sticker from a local real estate agency where Sandra had worked part-time, and also because I had seen Sandra drive this specific vehicle approximately 40 times. It was unmistakably her car. It was unmistakably in my garage, and the garage door, which required my personal code to open, had been opened. I took out my phone and took 12 photographs of the vehicle from different angles. I photographed the parking permit. I photographed the license plate. I photographed the interior door to my house, which was still locked and showed no sign of forced entry. I photographed the garage door opener panel on the wall. Then I walked back outside, closed the garage door, locked it manually with the keyed lock I had installed on the exterior side, and sat in my truck and called a locksmith. The locksmith arrived within the hour. I had him change the exterior keypad code, rekey the manual exterior lock, and rekey the interior deadbolt. While he was working, I called my neighbor across the street, a retired pharmacist named Bernard Osei, who had lived in Cedarwood Park since it was built, and who possessed both an excellent memory and a rooted distrust of anyone who used committee positions as personal leverage. I asked Bernard if he had noticed anything unusual about my garage that day. Bernard said, in fact, he had seen a Cedarwood Park maintenance truck parked in front of my house that morning for about 40 minutes. He said he had assumed I had arranged some service work. He had not seen who was in the truck or whether anyone had gone into my garage. I thanked Bernard and hung up. Then I called the HOA management company, a firm called Lakeside Property Group that contracted with Cedarwood Park for operational management. I asked to speak to the property manager, a man named Gary Fenn. Gary was not available. I left a message describing the situation in specific terms, that a vehicle belonging to an HOA board member had been parked inside my locked private garage without my knowledge or permission, and that I wanted an explanation of how this had occurred before I decided on next steps. Gary called me back 40 minutes later. He sounded, when I described the situation, genuinely startled in a way that seemed real rather than performed. He said he was not aware of any situation involving my garage and had not authorized any access to my property. He said the maintenance crew had been in the neighborhood that morning for routine storm drain inspection, but he would need to check whether they had been near my property. He said he would call me back. He called me back in 20 minutes. He said the maintenance crew had indeed been near my street that morning, and that one member of the crew, a part-time employee who was also the husband of an HOA board member, had used the crew's emergency master code to access my garage door. The emergency master code was a maintenance override that could open any garage door in the development, and was supposed to be used only in genuine emergency situations with board authorization. Gary sounded pained when he told me this. He said this was not authorized use and did not reflect HOA policy. I asked him who had authorized the use of the emergency code. He said he was still looking into that. I said, Gary, I want to ask you something directly. Is the HOA board member whose husband is on the maintenance crew Sandra Fitch? There was a pause. He said he could not confirm that at this time. I said, I'm going to take that as a confirmation. He did not disagree. I thanked Gary and told him I would expect a written explanation of what had happened and what actions the HOA intended to take, delivered within 48 hours. He said he would do his best. I said his best needed to be sufficient. Then I sat in my truck, in my driveway, and thought about what I was going to do about the Escalade. Here is the thing about having someone else's vehicle in your garage without permission. Depending on your jurisdiction and the specific circumstances, your options exist on a spectrum. On one end, you call the police and report an unauthorized vehicle on your property and have it towed. That is the most direct option. On the other end, you do nothing immediately and let the situation develop while you think about what response will be most complete and most proportionate. I am, as I mentioned, not an impulsive man. I sat in my truck and I thought about Sandra Fitch, about the beige versus sand gate, about the teak furniture, about the basketball hoop, about the specific way she had positioned herself over 2 years as the person who decided what was acceptable in this neighborhood. And I thought about what it meant that she had used her access to HOA maintenance infrastructure to park her personal vehicle in my private garage while I was away from home. I did not call the tow truck that night. Instead, I called my brother Kevin, who lived 4 hours away in Richmond and had been asking me for months to come visit. I told Kevin I was thinking about coming to stay for a while, maybe a week, maybe 2. Kevin said that sounded great and that the guest room was ready whenever I wanted it. I said I might be coming sooner than expected. He said fine, the key was under the geranium on the porch. I told him not to do that with keys, that it was a security risk, and he told me I needed to relax and come visit. I spent that evening and the following morning handling 2 things. The first was documentation. I wrote a comprehensive account of everything, the timeline of my discovery, the photographs, the locksmith, Bernard's account of the maintenance truck, Gary Fenn's call, and what he had disclosed, the prior history of Sandra Fitch's interactions with my property. I organized everything into a folder and emailed copies to my personal email and to a cloud storage account I used for professional project documentation. The second thing I handled was the garage. Sandra's Escalade was locked. I was not going to touch it, move it, or interfere with it in any way. It was on my property without authorization, which created a specific legal situation, and I wanted to be clear on that situation before doing anything physical. I called a property attorney named Margaret Cho, whose name I had from a professional context. She had worked on an easement dispute on one of my engineering projects the previous year. I explained the situation. She said, Owen, an unauthorized vehicle on your property placed there without your consent is essentially a trespass. You can have it towed. You can also choose not to and simply secure your property around it and notify law enforcement of the unauthorized vehicle's presence without requesting immediate removal. She said the second option had a certain documentation value. I asked her what she meant. She said, if you tow it tonight, the story ends tonight. If you secure the garage and leave for your trip, the story continues, and every day that continues is another day of documented unauthorized occupation of your property, which has value if you later pursue civil remedies. I asked her how long I could reasonably do this. She said she would not recommend an extended period, weeks rather than months, and that I should file a police report either way today so there was a documented record of the unauthorized vehicle. She said I should also send written notice to Sandra Fitch directly via certified mail that her vehicle was on my property without authorization, that I was aware of it, and that I would determine the disposition of the vehicle at my discretion within a reasonable time frame consistent with applicable law. I filed the police report that afternoon. The officer who took the report, a young man named Davis, who seemed faintly bewildered by the specifics, confirmed that the vehicle was registered to Sandra Fitch, and noted the report without ordering immediate tow since there was no safety issue and I was not requesting removal at this time. He said I had the right to have it towed at any point and could call dispatch to arrange it. He gave me a report number. I sent the certified letter to Sandra Fitch that evening. The letter stated that her vehicle was present in my private garage without my authorization, that I was in possession of the vehicle report number from the county sheriff's office, that the emergency maintenance code had been used without proper authorization to access my property, and that I would be determining the appropriate disposition of the vehicle upon my return. I noted that I would be away from the property for an undetermined period. I packed a bag that night. The following morning, I drove to Richmond. Kevin's guest room was exactly as described. The geranium on the porch was thriving. Kevin himself was the same as always, 3 years older than me, considerably more relaxed than me, with a lab mix named Earl who greeted me at the door with the absolute conviction that my arrival was the best thing that had happened in recent memory. I had brought my laptop and could work remotely on the documentation and design review portion of my current project. I had arranged with my office that I would be working from Richmond for the next 10 to 14 days. I did not tell Kevin the full story right away. I told him I needed some time away from the neighborhood and that I had a situation I was managing from a distance. He said, "Is this an HOA thing?" I said it was. He said, "Owen, I have told you for 6 years to move somewhere without an HOA." I said I was aware of his position on this. He handed me a beer and asked if Earl could sleep in my room, and I said sure, because Earl was better company than most people I knew. I had been in Richmond for 3 days when Sandra Fitch called my cell phone. I let it go to voicemail. She left a message. The message was approximately 4 minutes long. I am going to describe it rather than quote it directly, because the specifics are less important than the overall character of the communication, which was this. Sandra Fitch had parked her car in my garage, she said, because she had needed a secure location for the vehicle for a few days while some work was being done in her own garage, and she had intended to move it before I returned but had experienced a scheduling issue, and she wanted to discuss retrieving the vehicle at my earliest convenience. She did not apologize. She mentioned twice that she was an HOA board member. She used the phrase community cooperation in a context that seemed to suggest that allowing her to use my private garage without permission was a form of being a good neighbor. She did not mention the emergency maintenance code. She did not explain how she had gotten into my locked garage. I listened to the message twice, then I saved it, then I sent it to Margaret Cho. Margaret called me back in 20 minutes. She said, "This message is remarkable." I said I agreed. She said the admission that she had intentionally parked the vehicle there and had intended to move it before you returned demonstrated clear knowledge that the parking was unauthorized and that discovery was something to be managed. She said this was valuable. She said the message had also been left without any legal advice, which people in Sandra's position often came to regret. I asked Margaret what she recommended. She said I should not call Sandra back directly. She said she would send a letter from her office on legal letterhead acknowledging receipt of the voicemail, confirming that the vehicle remained on my property under the filed police report, and requesting that any further communication be directed to her as my attorney of record. She said this would accomplish 2 things. It would tell Sandra that this was no longer a casual neighbor dispute, and it would stop Sandra from leaving more voicemails that she might later wish she hadn't left. Margaret sent the letter. I know this because Sandra Fitch stopped calling. I was in Richmond for 12 days. Kevin and I went fishing twice. Earl accompanied us both times and was unhelpful as a fishing companion, but excellent as general company. I ate dinner at Kevin's dining room table every night and slept better than I had in months, in the particular way you sleep well when you have done everything correctly and the next move belongs to someone else. On day 12, Margaret called and said the HOA's attorney had reached out. She said, "Owen, I think they'd like to resolve this. HOA Karen parked her SUV inside my garage, so I locked the door and left for 2 weeks." Margaret Cho had been practicing property and HOA law for 18 years. which meant she had seen most of the ways that people in positions of institutional authority made decisions they later deeply regretted. She had a calm, precise manner that I appreciated. She did not dramatize situations. She did not encourage her clients toward escalation for its own sake. And she gave advice that was grounded in what the law actually said rather than what would feel most satisfying in the moment. When she called me on day 12 in Richmond to tell me the HOA's attorney had reached out, her tone was the specific tone of someone who had expected this call and was not surprised by its timing. She said the HOA's attorney was a man named Paul Whitmore, and that Paul had indicated the HOA was very concerned about what had occurred and wanted to explore a resolution. She said Paul had been careful and had not made any admissions on behalf of the HOA or Sandra Fitch, but that the fact of the call itself was significant. An attorney reaching out at day 12, before any formal legal action had been filed, was the sound of an institution calculating its exposure and concluding that the calculation did not favor waiting. I asked Margaret what resolution looked like from her perspective. She said there were several components worth pursuing. First, formal written acknowledgement from the HOA that the Emergency Maintenance Code had been misused, that my property had been accessed without authorization, and that this constituted a breach of my rights as a property owner under both the HOA covenants and state law. Second, a change in the Emergency Code access policy, specifically a written policy requiring board president authorization before the emergency override could be used on any residential property, with a log maintained of all uses. Third, Sandra Fitch's removal from the Architectural Review Committee and the HOA board. Fourth, compensation for my documented out-of-pocket costs, the locksmith, my attorney fees, and any other directly attributable expenses. Margaret said she would also raise the question of the voicemail Sandra had left, which constituted a clear admission and which gave us considerable leverage. I asked about the civil trespass claim. She said we had won. She said it was worth filing if a negotiated resolution failed, but that the resolution itself, if it included all four components, was likely a better outcome than what a court would order after a long and expensive process. She said courts in HOA disputes tended toward practical remedies rather than punitive ones, and that what we were seeking in the negotiation was already more practically meaningful than what a judge was likely to order. I told her to proceed with the negotiation. I stayed in Richmond one more day while Margaret opened the formal discussion with Paul Whitmore. Earl and I took a long walk that afternoon through the park near Kevin's house, and Kevin came with us, and Kevin asked me how serious the situation was. I said it was significant but manageable. He asked if I was going to sue anyone. I said possibly, but I hoped not. He said, "Owen, you know what your problem is? You're too patient, you let things build up." I said I thought patience was generally a virtue. He said, "Not when someone parks their car in your garage, it's not." I thought about that. Then I said, "Actually, the patience was exactly right this time." He seemed unconvinced, but dropped it, which is one of Kevin's better qualities. Margaret called me the following morning with an update. Paul Whitmore had gone back to his clients and come back with an initial response. The HOA was willing to acknowledge that the emergency code had been misused and commit to a new written access policy. They were willing to cover the locksmith costs and a portion of Margaret's fees. They were not, at this stage, willing to commit to Sandra Fitch's removal from the board. Paul had indicated this was the sensitive point, that Sandra had supporters on the board who were pushing back on removal, and that the HOA was proposing instead that she step down from the Architectural Review Committee only. Margaret said, "They're trying to preserve her board position. I think they'll move on it if we hold firm, because the voicemail is genuinely damaging to her personally. But I wanted to check with you before I pushed." I thought about this for a moment. I thought about the basketball hoop, about the beige versus sand gate, about the teak furniture, and the 2 years of small structured harassments. I thought about Sandra Fitch leaving a 4-minute voicemail in which she did not apologize and mentioned twice that she was an HOA board member, as if that were a relevant credential for the act of parking her car in someone else's garage without permission. I told Margaret to hold firm on the board removal. She went back to Paul Whitmore. There was a 48-hour pause. During that pause, I packed my bag at Kevin's house, thanked him for the visit, said goodbye to Earl and drove home. I arrived at my house in the early afternoon. The garage was exactly as I had left it, locked. Sandra's Escalade inside, my truck in the driveway. The house itself was fine. Nothing had been disturbed. I made a note of this for the record and then made myself dinner and went to bed early. The next morning, Margaret called. She said Paul Whitmore had come back with a revised position. The HOA was now willing to accept all 4 components. Sandra Fitch would resign from the HOA board and the Architectural Review Committee. The written access policy would be implemented. The formal acknowledgement would be issued in writing on HOA letterhead and placed in the permanent HOA records. My locksmith fees, attorney fees to date, and a negotiated sum for the general disruption to my property rights would be covered. In exchange, I would agree not to pursue further civil action related to this specific incident, and I would release the vehicle to Sandra upon my execution of the settlement agreement. I asked Margaret if this was the right outcome. She said, "Owen, you got everything you asked for, yes." I told her to draw up the agreement. The settlement was executed 3 days later. Margaret and Paul handled the paperwork. The formal written acknowledgement from the HOA was on my desk by Friday morning, signed by Tom Birch, the HOA president, on official letterhead. It stated in plain language that the emergency garage access code had been used on my property without proper authorization, that this constituted an unauthorized entry to private property in violation of both HOA policy and the applicable provisions of state property law, and that the HOA acknowledged this breach and regretted the impact on my household. The language was careful and lawyered, but the substance was there. Sandra Fitch's resignation from the board was submitted in writing that same day. She did not make a statement. There was no farewell email to the neighborhood, no community post about her years of service. She simply submitted the resignation, and that was the end of her involvement with Cedarwood Park HOA governance. I drove to the garage that evening, opened the door, and called the number Sandra's attorney had provided. A man arrived within the hour, not Sandra, her attorney's assistant, and drove the Escalade away. I watched it back down my driveway and pull into the street and disappear around the corner. Then I pulled my sedan in from where I had been keeping it on the street, parked it in its proper spot, closed the garage door, and went inside. What happened next in Cedarwood Park happened at the pace that community change usually happens, slowly, in pieces, through people having conversations that eventually accumulated into something different from what had been there before. The new emergency code access policy was drafted by Gary Funn at the management company and presented at the next regular board meeting. It was thorough. It required written authorization from the board president before any residential garage could be accessed with the override. It required a documented reason. It required notification to the homeowner within 24 hours, and it required a log maintained by the management company with a copy available to any homeowner on request. The board passed it unanimously. Even the members who had supported Sandra's continued board membership voted for the policy. The Architectural Review Committee elected a new chair. Her name was Priya Duskshpta, and she had moved into Cedarwood Park 2 years earlier with her husband and 2 teenage sons. Priya was an architect by training, an actual architect, professionally licensed, with a genuine understanding of residential design standards and material compatibility. She sent a brief introduction letter to the neighborhood when she took the committee chair, and the letter managed to convey both that she took community standards seriously and that she intended to apply them fairly, which was a combination I had not experienced previously from that position. Several neighbors commented favorably on the letter at the next community cookout. Bernard Usser, my neighbor from across the street, stopped me in the driveway one morning about a month after the settlement and said, "Owen, I have to tell you something." I said, "Go ahead." He said, "I knew something was off when that maintenance truck was at your house. I should have called you right away. I'm sorry I didn't." I told him there was nothing to be sorry about. He hadn't had any reason to think something was wrong. He shook his head and said, "I've lived here 17 years. I know what's normal and what isn't. I should have called." He looked at me steadily. Don't let it happen again. I said I had changed the code. He said, I meant don't let it happen again because you call me if something doesn't look right. I said I would, and I meant it. There is a question I have been asked a few times since this happened, by friends and colleagues who have heard the story, which I have told carefully and accurately, the way I tell all stories, and the question is, why didn't you just call the police immediately and have it towed? Why the documentation, the lawyer, the Richmond trip, the 12 days? Why didn't you just handle it the fast way? I understand the question. It is a reasonable question, but I think it rests on a misunderstanding of what the goal was. If the goal had been simply to remove a car from my garage, the fast way would have been fine. Call dispatch, arrange the tow, move on. The car would have been gone the same night I discovered it. Sandra would have been angry, maybe briefly embarrassed, and then it would have been over. She would have remained on the board, retained her architectural review position, and continued doing exactly what she had been doing, using a position of community authority to manage and restrict the lives of people in a neighborhood she had decided she ran. That was not an acceptable outcome to me, not because I am vindictive, I genuinely am not, but because the conduct that had led to a car in my garage had been developing for 2 years, and the car in the garage was simply the most concrete and provable expression of a pattern that had been harming this community the whole time. If I handled it the fast way, I handled just the car. If I handled it the right way, I handled the pattern. The 12 days in Richmond were not punishment for Sandra Fitch. I want to be clear about that. They were time for the situation to develop fully, for the documentation to accumulate, for the legal picture to become clear, and for the HOA to understand that they were dealing with someone who was not going to make this convenient for them by accepting a fast and incomplete resolution. The patience was not passive. The patience was the strategy. My sedan sits in my garage where it has always sat. The garage door code is known to me and no one else. The new exterior lock, rekeyed by the locksmith on the evening I discovered Sandra's Escalade, has a single key on my keychain and a duplicate in my fireproof document safe. The emergency code access policy is in the HOA records, available to any homeowner who asks for it. The basketball hoop is in the driveway on weekends when my nephew visits. Per Appendix C, Paragraph 7, I store it in the garage between sessions, and I do this cheerfully because it is a reasonable rule and reasonable rules deserve reasonable compliance. Priya Deskchipta has never sent me a courtesy note about it. When I see her at the community pool or the mailbox, she waves and asks how the projects are going, meaning my engineering projects, because she is a fellow design professional and we have had actual conversations about actual things. That is what a neighbor looks like. That is what a community governance position used correctly looks like. I did not know I had been missing it until I had it back. 6 months after the settlement, I was walking Earl. I am watching Earl for Coven, who is traveling for work, and Earl has decided my guest room is acceptable, and I passed the end of the street where Sandra and her husband had lived. The house had a sold sign in the yard. A moving truck had been there the previous week. The new owners were a young couple, I had heard, with a dog and a vegetable garden they were planning to put in the side yard come spring. I thought about the vegetable garden. I thought about whether Appendix C had anything to say about vegetable gardens. I made a mental note to look it up when I got home, not to report anything, but so that if the new neighbors asked me, I would know the answer and could point them to the right section, and tell them exactly what was permitted and what wasn't, in the straightforward, complete, non-weaponized way that useful information is supposed to be shared between people who live near each other and are trying to build something that functions. That is what I was trying to build the whole time. Not a case against Sandra Fitch, though the case became necessary. Not a demonstration of my own patience and procedural correctness, though both served me well. Just a neighborhood that worked, one, where the rules applied equally, where the authority attached to positions of community trust was used for the purposes that trust was extended to serve, and where a man could park his own car in his own garage without returning home to find someone else's Escalade in the space. That is not a complicated thing to want. It should not require 2 weeks in Richmond and a property attorney to achieve it. But when it does, you do what the situation requires, and you do it the right way, and eventually you drive your sedan into your own garage and close the door and go inside and make yourself dinner, and that is enough. That has always been enough. Thumbnail text, Österusk. Her SUV was in my garage. I left for 2 weeks.